The UK's Supreme Court was established in 2009 to assume the judicial authority that was once held by the House of Lords. Like the US Supreme Court, it's the highest appellate court in the country and only hears cases of the greatest public and constitutional importance. If the panel believes a law is at odds with legal human rights mandates, it can tell Parliament to reconsider that legislation.
Supreme Court of the United Kingdom, Parliament Square, London, SW1P 3BD, 27th of September 2022, and their reference number. Dear Mr. Smith, I acknowledge receipt of your emails dated the 27th of September 2022. I'm sorry, but the justices and staff of the Supreme Court cannot intervene in the issues you raise. The Supreme Court is the final court of appeal in the UK for civil cases and for criminal cases from England, Wales and Northern Ireland. The Supreme Court hears cases of the greatest public or constitutional importance affecting the whole population. Unless one of the relevant courts listed here, and there is a link to the list of UK courts, has made an order affecting you, you will not be able to take your case to the Supreme Court. Furthermore, not all orders made by lower courts can be appealed to the Supreme Court. Unfortunately, we cannot advise you on what action you should take now. You might want to get advice from an accredited legal professional or support network. Yours sincerely, Robert Greenberg, Chief Case Manager, Registry Manager, on behalf of the Register of the Supreme Court of the United Kingdom. From We the People, Crewin House, CLC Embassy, 1 Wurzburg Court, Dundee. On behalf of the people, I write to acknowledge receipt of your email dated 27th of September 2022. First of all, I wish to complain about the handling of the people's previously issued lawful notice and required hearing. This paperwork was sent by recorded delivery, signed for, and then the tracking number, on the 12th of August 2022, but was not replied to. It took numerous phone calls to address this, and only after I sent email confirmation on the 13th of September 2022 was this acknowledged. Despite being assured that I would receive a reply within the next week, none was received. I again had to phone, only to be informed this time that although the paperwork had been signed for, you were unable to find it, and I was then asked to send an email copy, which was done. In relation to this matter, although I had informed your staff that the paperwork forwarded to you concerned issues of life and death, this did not seem to concern them, and the people are still awaiting a hearing to deal with this ruling. Is this standard procedure for the Supreme Court, as I can only presume that it is either down to incompetence, negligence, or criminal behaviour? Either way, it is not what the people expect from the country's highest statutory court. Moving on to your reply, the people are a bit confused, as you had pointed out that the justices and staff of the Supreme Court cannot intervene in the issues that were raised. The only thing that the people had required was a judicial ruling from the Supreme Court. Does the Supreme Court not deal with judicial rulings, or are the people mistaken? You then went on to say that the Supreme Court hears cases of the greatest public or constitutional importance affecting the whole population, yet you confirm that the Supreme Court will not address issues of crimes committed against the whole population by the courts, police, and the state. What is more important than constitutional abuse by the state? We the people again write to confirm that we require a hearing with the UK Supreme Court. This will be used to obtain a judicial ruling as a matter of urgency. The numerous issues, including life and death matters, have been confirmed in our paperwork. In conclusion, as previously mentioned, a copy of your response and this notice will be published on the CLC website for information purposes. If this matter is not resolved within the next 7 days, we will be taking this matter further. We the people, subject solely to the authority and jurisdiction of the Common Law Court. Supreme Court of the United Kingdom, Parliament Square, London, SW1P3BD. Dear Mr. Smith, I acknowledge receipt of your email dated the 10th of October 2022. I am sorry, but your documents are of no legal effect in the United Kingdom, and they are not binding on the UK Supreme Court or any lower court. Common law does not mean that statutes are not valid. They are. It does not mean that people only have to obey laws that they agree with. People are bound by the whole of the law in the country they live in. No country has ever given citizens a choice whether to comply with laws or not. If you send any more notices of this sort, we will not reply. We suggest you seek independent legal advice. We trust this assists. Yours sincerely, Robert Greenberg, Chief Case Manager, Registry Manager, on behalf of the Deputy Support Registrar of the Supreme Court of the United Kingdom. Okay, so first of all, both the original physical notice and the subsequent email copy that we sent were not sent from any one individual. It is clearly headed at the top of the first page that this is a notice from we the people. It goes on to say that in this case, the people will be represented by the living man, John Smith. So why are both of their subsequent communications addressed to a Mr. Smith, a completely separate legal entity which had never been mentioned in any of our communications? Secondly, at no point in either of their responses do they ever even address one of the multiple issues that we have raised with them. They declare that, unless one of the relevant courts listed here has made an order affecting you, you will not be able to take your case to the Supreme Court. Our attached paperwork listed 75 such cases and 225 such issues, along with 29 prime examples of the types of crime being committed against the people on a daily basis by the offices of the state for financial gain. They then go on to say that our documents are of no legal effect and are not binding on any court in the United Kingdom. Perhaps not legally, that is, pertaining to commerce and contracts, but they are of lawful effect and they are lawfully binding. And common law does not proclaim that statutes are not valid. They are, but only within the statutory system itself and by mutual contractual consent. We point out to them that it is within their own rules, which their courts and offices are bound by, that all statutory courts are corporations and can only deal with other legal persons or corporations, and that any legal person or corporation is unable to obtain parity with a living man or woman, and therefore they will never have any authority or jurisdiction over them. Statutory legislation is unenforceable without consent, a valid contract, authority, and jurisdiction. To enforce compliance is criminal coercion, slavery, and a breach of our inherent birthrights. These things have already been ruled upon by previous Supreme Courts and stand as a fact in law. We had simply asked for a ruling with regard to the issues that we had raised. As for no country having ever given its citizens a choice, we are not citizens. A citizen is a pauper and a slave in Roman canon law, and to insist otherwise clearly breaches their United Nations Universal Declaration of Human Rights, which categorically states, no one may be compelled to belong to an association. No one shall be held in slavery or servitude, and that slavery shall be prohibited in all its forms. Might I suggest that they should seek independent legal advice to brush up on their own rules and regulations? ignorance of the law is no defence in law. When employees of the state are allowed to go about their business unchecked and unchastised, firm in the belief that they are automatically in the right and above the law, criminal activity will always occur. Is this the sort of society that you agree to be a part of? Can your conscience allow you to simply accept this sort of tyrannical conduct? I will leave you with this brief reminder of what the state itself deems to be acceptable.